Having listened to the last part of the first session, I'm obviously speaking to an impressively qualified audience, so I do so with a degree of diffidence as someone who's spent most of his recent life on the bench rather than arbitrating, although we have seen a number of interesting issues, particularly under the New York Convention, in the courts. The hallmark of arbitration is autonomy. The parties choose that their dispute should be determined by a tribunal, one or more, rather than in a court to which, whether in accordance with their will or against their will, they might otherwise be taken. And there are a variety of reasons for such choice, as I'm sure you're all aware, and I won't go into them. Choice of forum is, of course, possible in litigation, but arbitration has the huge advantage of the New York Convention, to which reference has already been made. As of yet, the Hague Choice of Court Convention 2005, admirable in itself, only has the EU, Denmark, Singapore, and Mexico as ratifying states. Hopefully, it will achieve more adherence, and indeed, with Brexit, one of them will no doubt be the UK, which will then be able to apply the Choice of Court Convention against its former fellow EU members. But that is by the by. What I want to do is just look at the scope of the choice which parties can make about the principles governing any dispute which they agree to arbitrate. And that, of course, has several aspects, at least two, if not sometimes three. The first concerns the substantive subject matter, or as one might call it, business, in respect to which the parties agree to arbitrate, which is commonly some relationship or transaction between them, though that is perhaps stretching a description if one's talking about investment treaty arbitration. The second concerns their agreement to arbitrate, which is now generally accepted as separate from the actual substantive business, even if it's embodied in the same document. See the Fiona Trust case and Privalov in 2007 in this jurisdiction. And the third, of course, concerns the procedure to be followed in the arbitration, which may in some respects be mandated by an arbitration law at the place of the seat. In other respects, it may be agreed by parties. And normally, the law governing the arbitration agreement will, I think, coincide with the law of the seat, and will also be the law which the parties have at least implicitly chosen to govern procedure. It's certainly something of a recipe of confusion to choose a different law to govern procedure from that governing the agreement to arbitrate. Now, how far can parties choose the principles which will govern the determination of disputes relating to the business, the subject of the arbitration? Well, normally parties intend that their disputes shall be determined in accordance with law, whether that means domestic law or international law. But in theory, they can choose anything they like. Indeed, you can certainly choose to determine the dispute by tossing a coin if you want. You can also, of course, more realistically confer on arbitrators the power to act as aimable compositeur or ex aequo et bono, that is, equitably without reference to any legal principles. No doubt that would bind. I don't think it's really sensible to describe tossing a coin as an arbitration at all, but aimable compositeur certainly is, and the English Arbitration Act permits parties to agree on arbitration by reference to principles which aren't strictly legal. Section 46(1)(b) says if the parties so agree, the dispute may be settled by the arbitral tribunal in accordance with such other considerations than the law chosen as are agreed by them or determined by the tribunal. Well, courts tend to construe clauses like interpret this reinsurance as an honourable engagement as not intending the arbitrators to depart from the law. I was in a case as long ago as 1989 where as counsel, home and overseas insurance company and mentor insurance company, where the Court of Appeal held that that provision didn't really give you complete freedom as arbitrators. It simply encouraged what we would nowadays call a purposive or teleological construction, which is what you anyway do normally with contracts. So assuming parties do wish their dispute to be decided by law rather than in some other way, what law and how is it ascertained? Well, if the parties have chosen a particular law, of course, that is relatively easy, and it shall be taken usually to refer to the substantive law of the country chosen. Otherwise, you have endless circles or voyages according to different choice of court provisions in different laws from one law to another. The problems arise, of course, if arbitrators haven't expressly chosen a law. The arbitration agreement may provide its own guidance, a private set of choice of law rules to cater for the situation, may tell the arbitrators to apply the law of the jurisdiction with the closest connection to the subject matter of the business or closest connection to the actual dispute which has arisen, or it may tell arbitrators to look at the choice of law rules of all potentially relevant jurisdictions in the hope, presumably, they may all agree or at least point in a clear direction. Or it may direct the arbitrators to internationally accepted principles. A number of institutional rules say that in the absence of any such agreement on the proper law to apply, the arbitration tribunal shall apply the rules of law which it determines to be appropriate. That seems a rather vague formula. The English Arbitration Act says if there isn't any choice or agreement, the tribunal shall apply the law determined by the conflict of laws rules which it considers applicable. That sounds a bit tougher. In other words, it sounds as if you're looking at conflicts of laws, rules, which are ascertainable as a matter presumably of law, so that under English practice, at any rate, a court might review whether the arbitrators had correctly identified the applicable conflicts of law or rules. So it's a rather tighter formula than the institutional formula of the ICC or the Hong Kong International Arbitration Centre rules, which provide, as I've said, that in the absence of agreement, the arbitration tribunal shall apply the rules of law which it determines to be appropriate. As I say, that's a rather vague formula. Does it enable arbitrators to invent their own choice of law scheme, to look at the law with the closest connection if they want, or apply the choice of rules of all potentially relevant jurisdictions, if that's thought to help, etc. The law with the closest connection to the business certainly gives a stable solution. All the other possibilities seem to present difficulties. To take the law with the closest connection to the dispute is clearly suspect, since the applicable law will then vary according to the precise nature of the dispute which arises. To look at the choice of law rules of all potentially relevant jurisdictions seems to me ultimately fruitless. If they all reach the same result, the exercise is unnecessary. You could look at any one of them. And if they differ, some means of choosing between them has to be invented. So, in either event, the exercise may have involved quite substantial labour to no purpose. An appeal to internationally accepted principles suffers from the same problems as appeals to the lex mercatoria generally. Whatever idealists may maintain, it never proves easy to identify any uniform principles at a worldwide level or even a regional level. A fourth suggested possibility, which is to forego any choice of law rules, and to proceed directly to apply whatever law the arbitrators think appropriate, appears to me to involve a process of divination rather than law. I get that from something that Sir Sidney Kentridge once said in a judgment in South Africa. If the language used by the lawgiver is ignored in favour of a general resort to values, the result is not interpretation but divination, he said. Well, it seems to me that this would also be gut reaction, is another way of putting it. In the last analysis, the conventional approach, where no particular law has been directly or indirectly chosen, appears to be to revert to the choice of law rules of the law governing the arbitration, the law of its legal seat, wherever it may in fact sit. As I've suggested, that may well be the right interpretation of the English Arbitration Act. And of course, English law choice of court rules choice of law rules are at present found in the Rome regulation, the European Union regulation, which I'm sure will be continued having looked at the draft withdrawal agreement yesterday, it provides that it should continue to apply in the UK after Brexit, and one way or another, one would be reasonably certain that that will be the case. If such things are not uncontroversial, then nothing will ever be agreed. Be that as it may, it would, in certain circumstances, wherever there is a contractual provision which points to particular choice of identifiable choice of law rules, as I've said, under English law, that would be reviewable potentially by the courts for the correctness of the choice made by arbitrators. What I'd like to do in the rest of this talk is just look at three aspects. The first is assuming that parties can and do select, or that there is in some way identified, a governing law. What is a governing law of the substance of the issue, of the matter in issue, the business in issue? Are there limitations on that? Secondly, are there limitations arising from the law of governing the arbitration, the law of the seat? And thirdly, are there limitations arising from the law of any third state? Just taking the first, it's obvious if you choose a particular law, that law may contain provisions which cannot be derogated from by agreement and will therefore override some aspect of your agreement. Gary Bourne, I think, in his book on international commercial arbitration, at pages 2707 to 8, floats a suggestion that if you select a governing law, that doesn't import mandatory provisions of that law, such as competition law rules, trade controls. That seems to me rather unconvincing. If you select a common law system, I would have thought you did select the rules in that respect. And they include, for example, other rules, such as the rules relating to penalties. At common law, of course, the legality of a substantive agreement isn't necessarily confined to be determined by reference to the provisions of the law you've chosen. The law of the place of performance, if that's in some third country, may also be relevant to the legality of the agreement under its proper law. But, for example, if you agree under English law something which necessarily involves the performance abroad of an unlawful act, unlawful by the law of the place where the act is to be performed, the contract will, to that extent, be unlawful and unenforceable. Raleigh Brothers and Asnar in 1920 is the authority for that, a case where a freight agreement under English law required payment in Spain, I think that was the place of discharge, of additional freight, which it was unlawful under Spanish law to demand. And the English courts held the agreement was pro tanto unlawful. Similarly, if the agreement could be performed legally, but the parties in fact intend it to be performed in a manner which is unlawful under the law of the place where they in fact intend it to be performed, it will again be unlawful and unenforceable pro tanto under its governing law. The cases there are Foster and Driscoll in 1929 and Regazzoni and Scythia in 1944. The facts in the former case are irresistible. They involved 5 over-ambitious joint venturers who entertained the project of smuggling a boatload of whiskey into the USA, which was then bound by prohibition. The project was financed by a Knight of the Realm and Member of Parliament. 2 other participants were shipbrokers. The whiskey supplier, or proposed whiskey supplier, was, as one might expect, an Edinburgh distiller. And the 5th joint venture, who was entrusted with the disposal of the whiskey in the United States, was so entrusted for unstated reasons which are not obviously associated with his career, which was as a retired schoolmaster living in Worthing on the south coast. Unsurprisingly, this disparate fivesome fell out. The joint venture had no success whatever except to clarify English law, which of course is a considerable virtue which any litigant should be well advised to remember. The common law principles in these cases are now preserved and permitted in the UK. They aren't required by the Rome regulation, which simply says effect may be given to the overriding mandatory provisions of the law of the country where the obligations arising out of the contract have to be or have been performed, insofar as those overriding mandatory provisions render the performance of the contract unlawful. So law of place of performance still is important, potentially, but that's only permissive. It's not compulsory as it is under English law. In other European countries, I think law of place of performance doesn't have the same significance as it does in UK law. There are also provisions in the Rome regulation about the law of the forum, which is my second topic. The regulation is concerned, of course, with court proceedings, so it means the forum of any court before which the matter comes, but that can have an indirect relevance to arbitration, because arbitration matters sometimes come before a court, and courts are generally expect arbitrators to take some notice of the general law. And the regulation says that as a matter of public interest, in exceptional circumstances, courts may apply exceptions based on public policy and overriding mandatory provisions. These are meant to be exceptions to the law which would otherwise be applied to the relevant contractual obligations. And one can, I think, take in the same bracket mandatory provisions of the law of the forum and public policy of the forum, and consider how they may override what would otherwise be the governing law, the law governing the substance of the business. And as I've said, viewing the matter at least through common law eyes, where there's a certain degree of supervision of arbitration tribunals, it would seem that a modern arbitration tribunal would be well advised to take account of the mandatory overriding rules and the public policy of the law of its seat in all cases. If they purported to ignore those provisions, then it is certainly the case, both under common law and under European Union law, that this should be reviewed if the matter comes to court. Indeed, the case law of the European Court of Justice establishes that it is for the courts of the law of the seat of an arbitration to correct the position by review, irrespective of the purely domestic law position, if a tribunal fails to take account of mandatory provisions of EU law, such as protective employment law or consumer law rules or competition law principles or antitrust laws. The case there is Echo Suisse China Time Limited against Benetton International. On the other hand, in fact, the challenge in that case failed because the court, one of the parties had failed to raise the challenge under domestic procedural rules in time, and the Court of Justice of the European Union held that that could mean that the award became unchallengeable, even though its result was to overlook an infringement of mandatory EU law rules. They may not have been quite so kind, the European Court of Justice, in more recent jurisprudence, which I may have time to come to, but may not. That's the Achmea case. That being the position, of course, it's difficult to think that a different result could be achieved by, in a European forum, by the simple device of making the partners' relationship or transaction subject to the law of a jurisdiction outside the EU. An arbitration tribunal sitting in the EU could hardly ignore EU competition law or protective consumer legislation simply because the parties have determined that their disputes should be arbitrated by the law of, say, Canada. How you get to that result is perhaps not quite so clear, but as I've said, the probable underlying rationale is that, at least at common law eyes, an arbitration tribunal which ignored the mandatory law or public policy of its seat would have its award liable to be set aside or not enforced by the courts of the seat. and I don't think that arbitration tribunals could properly, parties agreeing to arbitration could properly conclude an agreement that mandatory provisions or public policy of the law of seat should be ignored. Again, Gary Bourne suggests that if such a provision were included, then the parties could, the arbitrators could ignore it. They could effectively override the parties' agreement and nevertheless apply the mandatory provisions or public policy of the law of the seat. Again, I would question that. It seems to me more likely that the result of such an agreement would be to make the arbitration agreement invalid. If you purport to exclude the public policy or mandatory provisions of the law of your chosen seat, the arbitration agreement is, I think, likely to be invalid, and there's some support for that in an English case called Accentuate and Asigra. The third area I want to just touch on is the area which arises when an arbitration tribunal is asked to take account of the mandatory provisions or public policy of a law which is not the governing law of the business which is being arbitrated, the issue, and is not the governing law of the seat. It's a third state law. Now, such a law may nonetheless have a real connection with the issues being arbitrated. It may be the law of a place where one or other party might also wish to enforce an award. What are arbitrators to do? What are courts to do? Well, of course, arbitrators can't ensure that their awards are enforceable in every realm in the land, but there may be some limits to the ability of arbitrators to ignore third state laws. An example of an issue along these lines came before the English courts in the case I've just mentioned, Accentuate and Asigra, in 2009. The arbitration there was agreed to be in Canada and agreed to be of a dispute subject to Canadian law, but it involved the activities of a commercial agent acting within the EU for a Canadian principal. The commercial agent was an English company which agreed to distribute software belonging to the Canadian licensor. The contract contained not only an arbitration clause in favour of Toronto, but a choice of law clause in favour of Ontario law. The claimant, the English company, the agent, gave notice of a claim under the Commercial Agents Council Directive Regulations of 1993. That's the EU regulations which benefit commercial agents whose contracts are terminated. In riposte, the licensor, the Canadian licensor, started a Toronto arbitration, and the commercial agent participated in it, submitting that its claim under the regulations was outside the scope of the arbitration clause. That was a submission which was rejected. And in the alternative, seeking to rely on the claim by way of counterclaim. The arbitrators also rejected the counterclaim because, they said, the parties' rights and obligations must be decided as agreed by Ontario law, and Ontario law doesn't incorporate the commercial agent's directive of the European Union. Now, the arbitrators were conscious that there was some slight difficulty about this area, but they contented themselves by noting in passing there may be interesting academic and intriguing domestic and international policy reasons why an arbitral tribunal should or should not apply the lex non contractus, in other words, a law other than that chosen by the parties, a third state law. But then they said, rather perhaps slightly curiously, this is not a debate for this tribunal. Well, I would have thought it was a debate for precisely a tribunal in their position, because it wouldn't arise in other situations. Anyway, they went on, while a principal purpose of the English regulation, according to the European Court of Justice, may be to protect for all commercial agents freedom of establishment and operation of undistorted competition in the internal market, this doesn't justify restricting the parties' freedom to choose a desired governing law in Ontario. So they took a firmly restricted view of their jurisdiction, and that, according again to Gary Bourne, doesn't appear to be the general jurisprudence of all tribunals. Some tribunals appear to have looked variously at other laws. Maybe there was some key in the particular arbitration agreement which enabled them to do so. But the follow-on from that decision, arbitral decision in Canada was English proceedings, because the English agent then commenced proceedings in England claiming that the commercial agency regulations applied in England as a matter of overriding mandatory law and claiming compensation, and they succeeded. In the eyes of the English court, the arbitration clause in favour of Toronto fell to be regarded as null and void or inoperative insofar as it purported to submit to arbitration in Ontario, outside the EU, a claim involving regulations which were under EU law and therefore under UK law mandatorily applicable within the EU law, within the EU, whatever the governing law of the agency relationship. Nonetheless, the judge recognised the difficult position in which the arbitrators had found themselves, since he added in his judgment that nothing should be taken as a criticism by me of the conduct or reasoning of the arbitral tribunal. And that case has been followed since in Firm Computer in 2014. It also has a famous precursor in the US Supreme Court back in 1985, Mitsubishi and Solar Chrysler Plymouth, where an agreement to arbitrate claims between Mitsubishi as a car manufacturer and a Puerto Rican distributor was expressed to be subject to Swiss law and provided for arbitration in Japan. Claims were made by the distributor against Mitsubishi under the US Antitrust Sherman Act in the US federal courts. The question arose, bearing in mind the agreement to arbitrate, shouldn't the action be stayed? The objection made by Solar was, well, if it goes off to arbitration in Japan, that'll be subject to Swiss law, and the law of the forum will be Japan, and there'll be no question of applying the US Antitrust Sherman Act in Japan. The answer which the Supreme Court gave to that was that if that had been the case, they would have had little hesitation in condemning the agreement as against public policy. But since Mitsubishi had conceded that the Sherman Act should, as a matter of agreement, be applied in the Japanese arbitration, it was unnecessary to, the Japanese arbitration could go ahead. Let me just touch briefly, if I've got time, on Achmea. That seems to me a rather different kettle of fish. I don't know whether you're all familiar with it, but in that case, the European Court of Justice has held that bilateral investment treaties, intra-EU bilateral investment treaties, as between, in that case, Czechoslovakia, to which the Slovak Republic had succeeded, and the Netherlands, are invalid because, at least insofar as any question of EU law could arise, because of the risk that the tribunal might err in the application of EU law, and because, in the European Court's view, bilateral investment treaty arbitrations can't be seen as a form of state dispute resolution mechanism which would enable the tribunals to make a reference to the Court of Justice on any issue of EU law, but also because, and some might think this moves in a directly opposite direction, in the Court's view, the establishment of such tribunals by states was a breach of the principle of sincere cooperation and mutual respect towards the European Union institutions. So the long and the short is that that's because of the risk that EU law might not be applied or might not be correctly applied. Apparently, internal intra-EU bits are invalid, even though in that case the bit actually provided that the arbitrators could apply EU law, the law in force of the contracting party concerned, amongst other things. What that leaves, where that leaves the position with third-party bits, in other words, a bit entered into between an EU state, or indeed the EU itself, and some third country, like the Canadian trade agreement, is something which might have to be, and I think is being litigated in front of the European Court. what the court did say in Acmea was that commercial arbitration was different, with the proviso that commercial arbitrations must be open to review in court to the extent necessary to enable a reference to the European Court of Justice on any fundamental provisions of EU law arising. The distinction between BIT arbitrations and commercial arbitrations seems, to say the least, open to some question, but no doubt the European Court would stick by it, because otherwise it would really be putting the cat among the pigeons. That is an interesting case, obviously, which has aroused a good deal of discussion. The effect may well be to encourage future investment arbitration tribunals to choose a seat outside the EU, if and when they have such a choice. And we may envisage further issues like those raised in the commercial agency case of Accentuate, which I mentioned. London, after Brexit, may even become a rather more attractive forum into which, or an even more attractive forum in which to pursue investment arbitration claims outside the EU, because then at least, even if they're unenforceable within the EU, they may be enforceable in London or in countries outside the EU, notwithstanding the public policy and mandatory overriding provisions that would apply under Acmea within the EU. May I just conclude by saying I think there is, from a private international law or conflict of laws viewpoint, a case for more developed rules about the circumstances in which both international investment arbitrators and commercial arbitrators, and indeed courts, should take account of the public policy or overriding mandatory provisions of any legal system other than that whose law governs the substantive dispute, or that of the forum of the arbitration. Might it not, I referred to the English principles according to which if you, under an English law contract, can be shown to either be going to breach or intending to breach the law of the place of performance, the contract will be pro tanto invalid. Invalidation is, however, a crude tool. Might it not be possible to develop an alternative rule whereby arbitrators and courts were entitled to take account of and apply the public policy and overriding mandatory provisions of the contractual or intended place of performance, not to invalidate, but to give effect to them? That would achieve perhaps better integration of different legal systems. The International Law Institute has actually looked at this area in 1991 and suggested if regard is to be had to mandatory provisions of a law other than that of the forum or that chosen by the parties, then such provisions can only prevent the chosen law from being applied if there's a close link between the contract and the country of that law, and if they further such aims as are generally accepted by the international community. Unfortunately, it seems to me this illustrates rather than solves the difficulty of deciding when it may be appropriate to take account of a third state law other than that of the forum or that which governs the substantive issue. As I mentioned, arbitrators can never ensure and should never aim to ensure that their award will be valid in every jurisdiction of the world, but it doesn't help them much to say that they should ensure that where there is a close link with the third state and you would be furthering aims generally accepted internationally. Those are such vague criteria that one must hope, I think, that the International Law Institute or some other body may try to be more specific. Thank you for your attention.